The Supreme Court of Appeal has issued a landmark judgment which will have significant implications for the application of BEE rules on preferential procurement policy. Joining me to discuss this case is the applicant, Piet le Roux, who's the CEO of Sakeliga. Piet, welcome. Could you give us some background on this case and how we got to this point?
David, yes, thank you for the opportunity. This case has been long in the making. In 2016, the then Finance Minister Pravin Gordhan published regulations for comment, new regulations under the Public Procurement Framework Act. And the regulations are what gives flesh to that act and what determines how state-owned entities and organs of state, such as municipalities, how they procure. When he published that, we intervened and we recommended that the changes, but went through nevertheless. And so in 2017, we had to initiate litigation, and we have now ended up in the appeals court where we were successful in our application and where we were awarded costs in this case.
So in your view, Piet, what are the implications of this judgment? How does this potentially change procurement policy going forward?
Before the regulations, that's before 2017, public procurement was done by a points system. And between 10 and 20% of points scored could be altered depending on the empowerment and other criteria as provided for in the Public Procurement Framework Act. But then what happened in 2017, when the regulations were promulgated as we know them today, a door closed. The door closed on businesses that weren't 51% owned. And it became standard practice, widespread among state-owned entities and organs of state otherwise. For example, ESCOM, to say that a company has to be 51% black-owned, otherwise it will not even be considered. So the regulations allowed state-owned entities in their discretion to set pre-qualification criteria. And that effectively shut the door to the wide range of companies that should be competitively bidding in government procurement processes.
So Piet, in terms of next steps from here, do you foresee that the state might challenge this judgment?
It is possible that the state could appeal. There's still the Constitutional Court to appeal to. We'll have to see. I think that the judgment is strongly in our favor, as is suggested by the fact that we were awarded costs too. The state did grant, the court did grant the Minister of Finance, the new Minister of Finance, Tito Mbeni, 12 months to correct the regulations, and so there's not an immediate suspension of the regulations. Unfortunately, we would have liked that, but nevertheless, I think there's a strong moral argument and a legal argument probably to be made that state-owned entities should not continue to apply these pre-qualification criteria. As for the way forward, it depends on the appeal. If there is an appeal, government is known for trying to legislate with deep pockets, but we're ready for them, and we will continue to see this through in the Constitutional Court if there is an appeal. But we are very confident of this because it's about a very important principle. Can you shut the door on businesses because they're white-owned, or do you have to at least consider the merits of the value proposition? And so I think it would be a travesty if a court were to say it's acceptable to shut the door to companies simply because they're not black-owned.
So Piet, in the judgment, the SCA indicated that the then Finance Minister, Pravin Gordhan, had acted ultra vires beyond the scope of his mandate and encroaching on the realm of the legislature. So what does this now mean in terms of pushing back against those kinds of actions by government officials? Do you see a way forward in which you could push back against that more strongly in future?
What sometimes happens in a country, in South Africa, this has happened for the past 10, 20 years, where there was an accelerating tendency for legislation to give discretion to ministers to extend those legislation by way of regulation. But Parliament, and in a parliamentary system as we know it in South Africa, Parliament is not supposed to be able to do away with its responsibility, not only its power, but its responsibility to consider legislation and to guard strongly the domains of regulation versus legislation. And what in this case happened was that probably in the spirit of this tendency to let ministers regulate or legislate as if they're regulating, Minister Gordhan went beyond his powers, and the court found that he effectively went beyond the scope of what is in the Public Procurement Framework Act and what is in the Constitution. And so by his regulation, he was trying to reform the law and the legislation as it stood. And I think that the case, of course, it has to be studied further, and we'll have to see if it can serve as case law in other cases. But I'm hopeful that it is a step in the direction of strengthening Parliament's hand in determining policy in the country, instead of letting bureaucrats run roughshod over Parliament's authority.
All right, Piet. Well, thank you very much. We will certainly be watching this development unfold in the coming months. And thank you for sharing your insights with us. If you enjoyed this video, please do give it a like, subscribe to the channel, and also check out the link below to our 30-day free trial, where you can get access to all of the CRA's reports and online briefings. That's it from me, David Ansara. Until tomorrow at 7 a.m. Take care.